Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner, and today we're talking about the doctrine of dual intent in the context of permanent residence. Keep in mind that permanent residence refers to the green card process. So if a person says that they are a green card holder, that means they're a permanent resident and vice versa. The doctrine of dual intent refers to the idea that a person who holds non-immigrant visa classification, a certain type of non-immigrant visa classifications, can have two intentions at the same time. They can intend to enter the United States with their non-immigrant visa classification on a temporary basis, and they can also intend to pursue permanent residence, or meaning they intend to live in the United States permanently, at least in the future. The doctrine of dual intent clearly applies to the H-1B and L visa classifications. It can also apply to the O-1 visa. With the O-1 visa and dual intent, you do have to show that you have a residence abroad that you plan to not abandon, or that you don't plan to abandon. The H-1B, with the H-1B and the L, it is possible to travel even while you have your adjustment of status pending. So when I say adjustment of status, that's the form I-485. When you submit the form I-485, you can also apply for what's called an advance parole document. That document allows a person to leave the United States while the green card is going on and re-enter the United States, or you can attempt to re-enter. You can use that document to apply for readmission to the United States without abandoning the I-485. If you are in H-1B or L status, it's possible to leave the United States as long as you meet certain requirements, even if you don't have a valid advance parole document. That's great news. That allows a lot more flexibility for individuals and these particular classifications. But remember, that only applies to certain non-immigrant visa classifications. Even if you have H-1B or L status, if you plan to travel and you are anywhere in the green card process, make sure you talk to your immigration attorney before you travel to make sure you have a solid plan in place and to make sure that everything continues to go smoothly. If you hold a different visa classification that is not dual intent, that absolutely does not mean that you cannot start the green card process while you are in the United States. You certainly can, or there is at least the possibility that you can, but keep in mind there are going to be restrictions on your ability to travel potentially, your ability to extend your non-immigrant visa classification or your non-immigrant status in the United States potentially. So those are all things that you need to talk through with your immigration attorney and make sure that they are part of your strategy. I hope you found this information useful. If you did, I hope you will share this information with a friend, share this video with a friend, and make sure you subscribe to our channel so you don't miss our next episode. Our next episode will be a high-level overview of the perm employment-based process. Until next time, my name is Emily Sumner with Sumner Immigration Law.